5, 4, 3, 2, 1, start. The reasoning which prevailed as such to impose the extreme penalty of death on account of the fact that the injuries were inflicted on the said persons when they were sleeping in a room in the wee hours of the day, and this act of the accused had shaken the conscience of the society at large, and the accused was guilty of such a diabolic act full stop. One of the persons, namely Tej Prakash alias Tari, had suffered injuries on the vital part of his body and thereafter forced to live a vegetative life full stop. The aggravating circumstances and mitigating circumstances were accordingly noticed by the court that the crime was not committed in heat of passion, but the same was pre-planned, since the accused had visited the house of his mother-in-law on 13 November 2012 and threatened to kill his wife and children on a failure of payment of rupees 35,000, and thereafter travelled about 15 kilometers from his village to commit the offence on 28 November 2012, since his wife and children were residing with his mother-in-law. Full stop. Stanza. The act of eliminating his wife and two innocent children and sister-in-law in a brutal manner, and the way assault had been carried out, led to the imposition of the extreme punishment. Full stop. The fact that the survivors would remain vulnerable because of their deposition against the appellant was also a ground to sentence him to death. Full stop. The trial court has marshalled the facts and rejected the ground of delay in lodging FIR by noticing that the FIR was lodged at 11 am, whereas incident took place at 5 am on 28 November 2012. Full stop. The complainant Rajiv Kumar had to make arrangement of a ambulance to take 6 injured to the hospital, and out of which 4 were declared as brought dead and 2 were seriously injured. Full stop. Stanza. Therefore, the first effort was to save the life of his family members, comprising of sisters, brother, nephew and niece, and thus the FIR could not be stated to be delayed in any manner. Full stop. Reliance was placed upon various judgments that the prosecution case would not be thrown away outrightly on this score. Full stop. The factum of injured being referred to LMC Ludhiana, and the fact that arrangements had to be made for post-mortem of our persons and the mental condition of the complainant was kept in mind while rejecting the plea of delay. Full stop. The factum of independent witness being not examined was rejected on the ground that at the time of occurrence eyewitnesses, namely PW17 Seri and PW23 Tej Prakash alias Tari, were present, and the fact that their statements could not be rejected as they had received injuries in the said incident and their presence cannot be denied. Full stop. Stanza. The argument of the defense counsel that PW2 Ranjit Kaur was not at the spot and had gone to the Gurdwara Sahib was rejected by the trial court, that the presence at the spot is quite natural, and being human, and she out of fear slipped away outside the house after seeing that her son-in-law inflicting injuries with the gandasi upon her daughter and the grandchildren, and hid herself in the bushes near the factory and came back home after half an hour. Full stop. Recovery of the weapon and the disclosure statement of exhibit PW19 being not recorded in the presence of any independent witness was rejected on the ground that it was only a rule of prudence, but the recovery of blood-stained clothes would find corroboration with the statement of PW2 Ranjit Kaur, who had stated that what the accused was wearing at the time of incident. Full stop. Stanza. Placing reliance upon the statement of PW17 Sherry and PW2 Ranjit Kaur apart from PW1 Rajiv Kumar, and the fact that they withheld The test of scrutiny during the lengthy cross-examination led the court to observe that it should not attach much significance to minor discrepancies. Full stop. The defense that the left arm of the accused had been amputated and the accused was not in a condition to cause a brutal murder was met with the reasoning that the arm was not amputated prior to the occurrence. Full stop. Rather, the accused was also admitted in civil hospital Fagwada on the same day in the evening and there was a wound on the left arm with stitches as per the statement of PW7 Dr. Brijesh Kumar Sharma and therefore amputation had taken place after the occurrence. Full stop. The motive aspect was kept in mind that a sum of rupees 35,000 was to be paid to the accused and his sister since the mother-in-law had arranged the marriage of sister of accused but the marriage had not worked out and Ranjit Kaur was instrumental for not ensuring the repayment of the money to the accused. Full stop. Stanza. Even the wife of the accused along with children had left the matrimonial house and come to her parents' house due to which the accused was nourishing a grudge. Full stop. The question of alibi that the accused himself was admitted in the civil hospital Fagwada at 6 p.m. on the said day for management and treatment due an accidental injury was brushed aside on the ground that there was 4 injuries recorded on the person of Tejendra Kumar which were stated to be received by a road accident when he was admitted in civil hospital Fagwada but when his statement was recorded by PW21 ASI Kashmir Singh he had not explained the manner in which he had received injuries. Full stop. The absence of the appellant from the place where his wife and 2 children had been done to death and not to come to the hospital and rather kept himself away were the circumstances which were kept in mind and the fact that he had taken the plea of false implication and had not taken the plea of alibi. Full stop. The nature of injuries on the persons of the deceased were also kept in mind that injuries were all inflicted on the head and vital parts of the body while they were sleeping in the early morning hours and thus there was only the intention to brutally kill them. Full stop. The injured Sherry, who was only 5 years old, also having received injuries on the right side of the neck just below the right ear and complaining of pain in the abdomen. Full stop. Stanza. He had also suffered a fracture and a splenic injury whereas the other injured Tej Prakash alias Tari had suffered injuries and a lacerated wound was present on the left parietal bone of the skull above left ear and a lacerated wound was present over the middle of parietal bone of the skull. Full stop. The other lacerated wound was present over the lower part of left lip and one over the middle of the left ear pinna were reasons to record the conviction under sections 325 and 308 IPC. Full stop. Stanza. The trial court had also noticed the fact that Tej Prakash alias Tari, aged 20 years, was unable to speak properly and understand the surrounding and unable to move without help of his mother and thus has been left with no option but to lead a vegetative life. Full stop. Blood-stained Gandasi having been recovered along with blood-stained clothes and the cycle on the basis of disclosure statement made by accused were the reasons to hold the appellant guilty. Full stop.